All right, let's see. We just hit the buttons. Let's see if this actually goes. Looks like everything's working. All right, cool. Well, good to see everybody today. Well, um, hopefully it's on better terms in the future. But anyway, so today there's really just a couple things that I kind of want to go through. And the hard part with this is I keep getting questions from all over the place, and I don't have time to text message and call everybody and kind of go through it. So I thought it would be easier. And there's really three things that we're going to cover today. We're going to go over Eric Olson's lawsuit against WFG. We're going to go over Paul Hart's resignation / termination. I still don't know exactly what's going on, but I have the resignation letter, so I'm assuming that he resigned. If anybody has any other information on that, email it to me. Just Mckensy Long at Hotmail. The spelling's the same. If you got any information that you want me to look at or go over, send it to that email. And then basically the progress of what this is looking like. How many people have moved over, kind of what's happening in everything that's going on with GFI. So let's just go ahead and get into it. But really, I think before we get started, I just want to make a single comment because I get a lot, I shouldn't say a lot, but most people are pretty supportive of what's going on here. I've gotten a lot of thank yous for kind of bringing some of this stuff to light. But what's interesting to me is the lack of transparency on both sides. And it's super frustrating, and I feel like we're in a political debate, and both sides are speaking politics instead of speaking what's actually going on. And the reason why this is so frustrating is because everybody who's involved in this has gone through training classes similar to that I have, in what we call dealing direct, right? And then if you have an issue with somebody, you guys go deal it direct. And that if people you need to have a conversation with somebody, you go and you have a conversation with them. But unfortunately, none of that's really happening. It seems like everybody just wants to get online and yell, or they're not saying anything, and so it just leads to all this wild speculation that I don't think needs to be happening. And we practice this stuff. We practice like resolution conflict all of the time, and it doesn't seem like any of the top leaders are using any of it right now. And so that's really why I wanted to kind of bring some of this stuff to light, and because it's a big decision. It's a big decision to leave your career path. It's something that you've been doing for decades and go do something else or go to another company. And so since nobody's going to sit down and have a conversation and talk about what's actually going on, I think the next best thing to that is just looking at the documents and the court documents, because that's literally what's happening. It's what one side is saying and what the other side is saying. And so we don't have time to go through all of it. There's literally 4 cases that are happening simultaneously. So GFI is suing WFG, Sandra is suing WFG, Eric is suing WFG, and then WFG is suing all of them. So we're kind of encompassing all of this together. But I wanted to go through this first part, which is basically Eric's complaints. And so this is what he's saying is why he's leaving WFG, and the reason why he's doing what he's doing. The next one that we'll go through maybe on Monday or something, if I have time to get through it through the weekend, is that what WFG is saying that Eric is doing. So you can see exactly everything behind the scenes of what's happening, and then you guys make your own decision on what you want to do, and so that you can explain it to your team, because I hate this lack of transparency and that nobody's actually talking about what's going on, and it's just all this political crap of if you're leaving, you're a traitor, and if you're staying, you're stupid because you don't understand contracts, and it's like, it's just so dumb. So let's go through it. I have some contract stuff. I've seen the contract that GFI has, so I'll kind of show that in a later video. We don't have time to get into that today. We only have about an hour together today, so we got to do this pretty dang fast. I also have what we'll talk about at the end is kind of what some of the progress and that stuff looks like. So let's just jump into the lawsuit, and then you can see exactly what's going on there, and we won't dilly-dally anymore. So this is the filing. It was actually filed. Let me switch over to that so I can see that directly, and we'll kind of just walk through the whole thing. So this was filed, I believe, January 26th. And this is going to be Eric's version. So just so you know, Eric's whole job here in this lawsuit is to make himself look good and to make WFG look bad, right? Because we're going to get 2 conflicting arguments. So this is going to be the worst of what Eric sees in WFG to make his case on why he should still get paid his millions of dollars. And then when WFG responds, they're going to show more of why they're good and why it's Eric's fault, okay? So let's kind of just get into that. What's interesting too is Eric wants a trial by jury. I don't know if that'll actually end up happening. Probably not. I don't think WFG would want it to go that way. I think they're going to want to be based on facts and not on people's opinions about what they think is going on and who's the good guy and who's the bad guy, but we'll kind of see. So, all right, so again, Eric Olson is the one that's alleging. The defendant is going to be World Financial Group. What's also interesting is he's saying that there's 10 does, 1 to 10 does. So basically, those are people that he doesn't know that are involved, but that he feels are involved. So I think that there's other people in this decision that have yet to be named. So we're going to start off. This is obviously going to be Eric's puff piece and kind of talking about where he came from, what he's been doing. He's talking about leaving San Diego State at 21 years old. He then started selling life insurance with WFG, annuities, similar products. Mr. Olson started at the bottom of level, multi-level marketing organization. Over the next 20 years, he built a $20 million per year insurance business comprised of 20,000 agents. His contract with WFG provided that he was an independent contractor and that the business he built, Pinnacle, belongs to him. In reliance on that contract, Mr. Olson recruited, trained, and managed those 20,000 agents to sell WFG products. In doing so, he made WFG and the people above him hundreds of millions of dollars. Over the last 3 years, Mr. Olson, oops, did I switch that? I don't know if you guys actually got a chance to see that. Let's do that. My apologies if you didn't get to see that part. You can screenshot that and kind of walk back through it. Over the next 3 years, over the last 3 years, over the last 3 years, Mr. Olson has become increasingly uncomfortable with some of WFG's business practices. Most significantly, WFG incentivizes its agents to recommend products sold by its parent company, Transamerica, even if they are not the best solution for the client, who rely on their agents' expertise, knowledge, and representation that they are getting the best product. WFG also creates a toxic atmosphere of distrust and demoting, suspending, and terminating agents without notice or cause, withholding commissions, reducing agents' compensation without notice, and arbitrarily and improperly offsetting against agents' earnings. Previously, WFG permitted contractors at Mr. Olson's level to transfer their commission stream, known as their code, to another contractor if he wanted to resign from the company, often through a code purchase to transfer to his spouse. Out of the dissatisfaction with WFG, Mr. Olson first attempted to transfer his business to his wife under WFG's Heritage program. When he told WFG what he planned to do, WFG tried to entice him to stay with the promises of tens of millions of dollars in additional compensation. So he must have turned that down. Yeah, when he declined those offers, they strung him along and then, without warning, eliminated the spouse transfer provision. Mr. Olson next tried to sell the business, as many of his predecessors had done. He knew that this was possible because a more senior contractor in his hierarchy, Rob Day, he had bought Rob Day's contract, had sold Mr. Olson part of his book for $5 million. After Mr. Olson told WFG that he wanted to sell his business, WFG prohibited him to do so. WFG's president, Todd Buchanan, told Mr. Olson that it's a free country. If you don't like it here, you can leave at any time. That sounds like something that would happen in a boardroom of people who can't seem to get along. So, but in reality, there is no way that he could do that. So basically, his complaint here is that WFG took away this program that allowed him to transfer it. Now, my question here, and maybe what we'll see come from WFG, is a lot of what's kind of happened is people use that spousal contract to then move people over. So, meaning if I'm like in ours, I'm the main, everything goes through my contract, right? And so if I wanted to move over, I would recruit my wife to a new business and then just start moving all of my people in my business over. So I'm assuming that WFG didn't get rid of that provision just to say, oh, nobody's able to do that anymore. I'm wondering if there were some threats or some conversation that happened behind the scenes where he said, well, I'm just going to start moving everybody over. And then they go, well, no, we don't want you to be able to do that. If you start moving people over, it's in direct violation with your contract. Or maybe he was thinking of having Sandra come over and then he was going to go build his own thing and kind of double dip on both sides, which is what it sounds like they were trying to prevent. So after Olsson turned down an approximately $20 million a year offer from WFG, WFG terminated Olsson's contract allegedly for cause, and divested him of his commission stream so that it now flows up to the people who worked to terminate him, including Rob Day and WFG. At the same time, WFG began threatening Mr. Olsson and the members of his team with an illegal non-compete clause in his contract with WFG. I'm not sure how that's illegal, but I'm sure we'll get into that. WFG's conduct constitute an illegal restraint on trade because it seeks to prevent employee mobility, impose $1 million penalties and forfeitures on individuals who seek to leave WFG's poisonous, poisonous environments, and frustrate competition. Well, I could understand why they probably wouldn't want new people coming out and creating competition. I mean, that kind of makes sense. Business doesn't always like competition. WFG has wrongfully terminated his contract, so he's saying that he's done nothing wrong to violate this contract. Tortuously interfered with Mr. Olsson's legitimate business interests and is unfairly competing against him. Has converted his assets and has violated the contract in good faith. So he's claiming that WFG, the covenant of good faith and fair dealing, so he's saying WFG is at fault for breaking this contract, not him. WFG is causing irreparable injury to Mr. Olsson on top of hundreds of millions of dollars in money damages it now owes him. It should be enjoined from trying to enforce its legal anti-competitive covenants to be required to pay compensatory and punitive damages to Mr. Olsson. Plaintiff Eric Olson is a citizen, so this is going to talk a little bit more about the parties, so it's just introducing Eric Olson. It's going to introduce WFG, and then it sounds like 10 other people that are kind of involved in this that he doesn't really know yet, so he's just kind of leaving that open for future reference if there's other people that are kind of involved for it. So each of the defendants, agents served company, performed beliefs here. These are talking more about those people that they were somehow involved in these conversations. Jurisdiction and venue. So this is just going to talk about where this is going to happen, kind of what they're expecting to kind of come out of it. So that it's more than $75,000 in damages. This is where they're going to kind of be looking at doing it. Then they're going to start introducing WFG. To be able to and talk about those. Okay, so Eric Olson built a $200 million business pursuant to his WFG contract. Around 2003, Mr. Olson signed a contract, the agreement, with WFG to work as an agent selling insurance and financial products. Upon information and belief, no agents are required to sign the annual renewal contract of an agreement each year without any opportunity to negotiate. So that's a fair point. I believe that they put out a new contract you have to sign if you want to keep working with them, and I don't know if you can really dispute that. You kind of just have to sign it and keep going on. So hypothetically, I guess they could make changes that were not in your best interest without you really having much negotiation power out of it. So in 2003, he's saying the latest iteration of it, WFG presented Mr. Olson with an independent contractor that he's not an employee of WFG. This agreement does not create an employment contract, agency, or any other type of relationship between the agent or any of the affiliated companies, including WFG. Over the years, Mr. Olson was told by WFG that he was a business owner and that he was encouraged by WFG to build his own business and recruit agents to work with him. The agreement is clear that agents are responsible for building their own business. For example, the agent is replete with language confirming the following. Agents shall be acting and shall always act as an independent contractor and are not employees of WFG or any of its affiliated companies. The parties shall operate their respective business separately and independently of each other and through the duration of this agreement, required to require insurance industry regulations and oversight from WFG. So WFG is responsible for the oversight. Agents shall not be obligated to contract with FG exclusively. And that's kind of the point I had with some of the conversations that I've had with people, is that there's nothing wrong with going out and starting another company. There's not anything wrong with going out and doing other things, which is kind of unique in the industry. I guess it's not as unique now, but if you work for New York Life, from my understanding, unless this has changed, you can't have income from anywhere else. So you have to flat out stop working your 9 to 5. You can't make money anywhere else, but you're not obligated to only make money with WFG. So he's allowed to go start another company. The question is he doing it in the right fashion? Recruited agents to work under him, provide financial products affiliated with WFG. Mr. Olson built up an extensive hierarchy, they call a roster of agents. Hierarchy built over 20,000 agents. I think it's a little exaggerated, but it's better to round up than round down, I guess. Eric Olson made WFG hundreds of millions of dollars for 20 years, has built his business, and WFG's benefited. Mr. Olson was incredibly successful in recruiting agents, training and managing his teams, and bringing significant sales to WFG. On average, Mr. Olson earned millions of dollars in commissions each year and often qualified for bonuses from WFG. Last year, Mr. Olson earned $20 million in commissions upon information and belief was entitled to $200,000 bonus to be paid this month in January, and $1 million to be paid in April, another $1 million to be made in June. So here's just another interesting comment as we kind of get into this. I bet you, what's interesting is companies always talk about having better comp, but I haven't really seen anybody make more anywhere else. So it's kind of interesting to see that too. WFG repeatedly recognizes his success in 21 years. He's never had any complaint. So this is interesting to me. Has never had any complaint. You don't have to be in WFG. You just have to be in the industry to know a little bit about Eric. He's got a reputation for taking people's people. This is not something new. So this is a huge fault on WFG if this is true. If they've never cited him for any of the things that he's done before and they're just now saying that he's done something wrong, I think this is a huge oversight on their part. Like I said, you don't even have to be in WFG to know that if your people go to one of his events or around his people, they're going to get recruited. Like that's just his model of doing business. And I've known so many good people that have left the industry or have left the company because their people have gotten recruited to his agency. That's just a fact. Like that's not disputable. But the fact that nobody ever made a complaint about it, he was never talked to about it, there's never been a meeting or an email about it, I don't know, man. That's fascinating to me. That's a huge oversight on WFG's part, in my personal opinion. In 2014, Eric Olson spoke at a convention. You can go watch that online if you want to, over 13,000 views. His strong leadership and commitment to help others has led to this impressive milestone. He is a fantastic leader. Nobody can dispute that, that's for sure. So you can go look at that if you want to see as well on Facebook. Mr. Olson became concerned with WFG's business practice. So this is where he's got to start leveraging his case and talking bad about WFG and all the things that they're doing. So let's see what he has to say about it. He became concerned with WFG's business practice, which financially benefited WFG to the detriment of its customers and the people who work hard to sell WFG products. Okay, let's see how he specifies that. For example, many people who buy life insurance or other products at WFG refers to heavily on the sales side, recommending the best products for them. WFG, however, pays its agents an extra 25% commission for recommending products sold by its parent company. So if you sell a Transamerica policy, you make more on that. I don't know if it's additional 25%, because even if you write nationwide, you get a little bit more. I think it's 108 or 110, which resulted in agents pushing clients into less suitable investments and products. In fact, at least one hierarchy in WFG sells only Transamerica. From my personal experience with Transamerica, I don't know how you could do a business purely on Transamerica business unless all of your clients are like 20 to 40 have never had any medical conditions, don't take any prescription drugs, have never had any health issues. Transamerica really wants the cream of the crop. I think they have some of the best products, especially when it comes to like the LB product. But to say that somebody can only run their agency on Transamerica products, I have a hard time believing that. I would say at least 30, if not 50% of the people that I used to even try to write up with Transamerica get declined. So at least half of the time, we don't even look at Transamerica for a lot of our clients. Yeah, because if they have any issues, Transamerica is not taking them for sure. It's like almost an automatic decline if they've coughed the wrong way. If they ever went to the doctor and said, "Hey, I'm feeling sad. I thought, I feel a little bit depressed," Transamerica's not taking them for sure. So WFG also routinely changed its compensation structure, disadvantaged its agents. Sometimes it would withhold commissions. Other times it would make offsets that took away earnings, and agents were powerless to do anything because WFG made the decision before paying out the agent. It would also eliminate promised bonuses. At the same time, WFG terminated many agents without notice or cause. I've never heard of that, but I mean, obviously, he's much higher up than I have, so I wouldn't have any evidence of that. Upon information or belief, changed its beneficiary rules that previously allowed an agent's spouse to receive their contract should the agent die. So basically, your code can be left to your spouse if you want to do that, so that way all this stuff that you're building doesn't just get left behind. You can actually leave it to your spouse. He's saying that changed, rendering agents unable to ensure spouses and family members received any benefit in the event of their death. The net effect of this conduct was to put more money into the pockets of WFG. So of course he's trying to say WFG is only doing that simply because they want to make more money. And in the top of the pyramid, while creating an environment of fear and distrust. As the results of these practices, Mr. Olson decided to leave WFG. WFG changed its own rules to enforce Mr. Olson to stay. So he's saying that they're changing the rules in order to keep him to stay. And I could understand that. Let's see what he has to say, and then I'll give my comment. So every WFG agent has a unique code, and the code is used to ensure that that agent receives compensation, and they're owed based on their unique code. In the past, agents like Mr. Olson also achieved considerable success having able to transfer or sell their unique codes and leave the company or take on different roles with the company. WFG explains it in its policy as the following. So at the third level of your program, you earn the ability to select a successor from your WFG business, while someone else, upon meeting the qualifications listed below, takes the leadership of your business. So basically, you can leave it to somebody else. Where it's developed depending on where you're at. Entrepreneurial efforts upon retirement, disability, or death, you can transfer that code over. In or about 2023, pursuant to WFG's policy, Mr. Olson contemplated transferring his code to his wife, Sandra, like many other leaders had done in the company before him, so that she could step into his shoes and be in control of his hierarchy and collect the revenues Mr. Olson was generating from the sales and the agents that were in his hierarchy. Miss Olson, as a businesswoman and entrepreneur in her own right, not only had prior experience with WFG, but also was well versed in the insurance industry. Mr. Olson informed WFG that he intended to transfer the code to her. However, WFG purported to terminate the program before he could do so. So again, we're talking about kind of the whole anchoring aspect of recruiting the spouse or having the spouse take over and then moving all of your people over into that new organization. So it sounds like they were trying to prevent that from happening in these negotiation talks. So in or around October 1st, Ms. Olson met with executives and WFG, Transamerica parent company at Pebble Beach. During this meeting, Mr. Olson assured the executives that Ms. Olson was more than capable, and they told him basically that he couldn't transfer his code. Because he could not transfer his code to his wife, Mr. Olson then sought to sell his code to another agent, which you're allowed to do. WFG rules allows agents to sell their unique codes, and in fact, Mr. Olson had purchased an upline code. WFG's policy is as follows. At this level, you qualify for the right to sell your WFG income stream and your hierarchy rights to another WFG agent. This level of reward is built into the business and therefore can earn from the entrepreneurial efforts upon the retirement, disability, or death, and then the different levels that you basically qualify to be able to do that. After Mr. Olson informed WFG of his intent to sell his code, however, WFG purported to terminate this program as well. So they're basically saying that they didn't want him to sell his code. That's kind of interesting. Without the ability to transfer his business to his spouse or sell the business to another agent. I don't know if they were doing this because they were trying to work on communication and they're saying, well, let's not do that. Let's see if we can work something out. I don't know. On January 19th, WFG scheduled a meeting in Texas with Mr. Olson to discuss his role at the company. So this is like right before the lawsuit happened. During the meeting, WFG offered Mr. Olson a role making approximately $20 million in supervising and overriding the additional 20 agents if he would stay with WFG. So they did make him an offer, $20 million a year to be able to stay on and kind of take more of a leadership role if you want to be able to do that. Frustrated by WFG's business practices, Olson refused the offer. WFG terminated Mr. Olson and takes his business. So on the 22nd, Mr. Olson received a letter of termination from WFG. In the letter, WFG claimed that Mr. Olson had terminated allegedly for cause, violating his contract and legal obligations to build a competing business. As a result of this decision, the people who decided to terminate Mr. Olson are now the beneficiaries of the revenues from those 20,000 agents in his hierarchy. WFG claimed that Mr. Olson had violated the non-solicitation, the confidential information, and the non-disparagement clauses. So those are going to be important moving forward. And this is what I would be looking for when you see all the social media stuff, and we'll talk about this in a little bit, and disparaging clauses. So what WFG is trying to say is that, well, you're soliciting our people, our agents and our clients. You're taking confidential information. You can't work for McDonald's and then take McDonald's system and go somewhere else and build something else with it. And then also non-disparaging. You can't badmouth your parents as you move out of your house, right? And still keep a good standing with them. So those are three things that I hope you're going to keep an eye out for in the social media stuff, because from what I've seen already, those three things have been broken. WFG's letter referring to paragraph 2.5, it's covenant with California law. Okay, so this is what he's basically citing as part of the reason why he's going. So except as prohibited by law during the period that agent is an agent with WFG, and for 2 periods, so this is after you leave, this is part of the contract. For a period of 2 years following the termination of this agreement, for any reason, agent shall, for either individually or in partnership or jointly or in conjunction with any other person, entity, principal, agent, consultant, contractor, employer, employee, or in any other manner directly or indirectly solicit, induce, or entice any way or in any other manner persuade or attempt to persuade any individual who is a current agent of WFG and with whom the agent had business contact with or on behalf of WFG and its affiliated related entities to terminate or after their agent relationship with WFG to join a competing company or organization. This non-recruitment restriction is limited and only applies with respect to any recruitment of an agent that resides in or engaged in business activities in the geographical area within 50 miles of the location of an agent's office during the 18-month period preceding recruitment. This provision survives the termination of the agreement. So basically, you're not allowed to go after your former company's clients, and you're not, mostly here what it's talking about is the recruiting aspect of it, but you're not able to go back and recruit WFG agents. So if you want to start a new company, you're allowed to do that. You're just not supposed to go in and raid the people who are working for WFG as you're moving out. So this is where the argument is coming from. It's not that, I mean, I'm sure they didn't want to see him go, but that's not the complaint here. The complaint here is, are you stealing our people? Are you soliciting? Are you inducing? Are you enticing any way or in any manner persuading or attempting to persuade individual who is current agent of WFG, that's a big no-no. You can't do that. So if that's happening, that's going to be a big issue for him in this lawsuit. Under California law, these restrictive covenants are illegal. Okay, so he's saying it's illegal to stop people from stealing people from your company. So he has relationships with all these people. He has their phone numbers, their contact information. He's saying that it should be, or that it is illegal to have a precedent like this. So in your company, you shouldn't have a non-compete or any kind of thing that says, hey, if you want to leave, don't take all these people with you, right? Like, go start something new if you want to, but just don't raid us in everything that we've done. And he's saying that that's illegal and cannot, or he's hoping, should not be enforced. Well, yeah, because he's breaking it. So of course he wants to say that it's illegal and should be enforced. But Mr. Olson has been in the business of building, training, and managing agents to sell insurance products for 20 years. To compete in this business, Mr. Olson must be able to recruit agents and sell life insurance and other products in California. Of course, you can do it in California, you just can't do it with WFG people. So I don't understand why that's an argument there, but he's trying to say that he can't do business at all if he can't recruit his old people. So the non-solicitation clause would restrict Mr. Olson from operating Pinnacle Elite business where his hierarchy is built with agents associated with WFG. Well, yeah, that's the point, right? Like, you got to leave that alone and then go start your own thing. If you want to be Christopher Columbus and go start something new, that's fine. Just go repopulate it yourself. It would also restrict Mr. Olson's ability to work at a new business where he would be restricted from recruiting new agents, the core feature of his work, and be at risk of violating the non-solicitation clause to reach out. Well, no, you can recruit new agents. You just can't recruit WFG agents. Feel free to recruit people all day long. Just don't recruit the agents that you're leaving behind. Like, don't disrupt the bandwagon on your way out. Like, I don't understand. So upon information and belief, all WFG agents are required to sign a non-solicitation provision, like the one referenced here in the termination letter, and it uses these provisions to intimidate and lock up its agents. So WFG says that if you want to leave, you can leave, just please don't raid our people. They do that to intimidate people and to lock up their agents. Okay, that's a fascinating. I wonder how many other companies have that. I think most major companies would have something similar. Like, if you want to go start something new, go do it. Just please leave the people alone. Without legal declaration at this provision is invalid. So he's saying this is invalid. You shouldn't have anything like this. Many WFG agents who are also subject to the same restrictive covenants fear that they might be sued by WFG if they violate the provisions. Yeah, that's normally what happens. You break the law, you get sued, or you break the contract, you get sued. At least some WFG agents fear that fighting the lawsuit against WFG is too costly, even if they prevail. Therefore, out of causation, these agents choose to comply with those provisions, even though they are illegal. So it's illegal to say, you can leave, just don't take people and clients from the former company. This atmosphere of fear and uncertainty hampers Mr. Olson's ability to continue to recruit them and grow his business. So because there's these, because he signed a contract that says he shouldn't be doing this stuff, it hampers the ability for him to continue to recruit and grow his business. Not only has WFG used this restriction to cause Mr. Olson to terminate and imperil his ability to earn money and seek new employment. I don't know how it stops him from seeking new employment. If he wanted to get a job at McDonald's, WFG is not going to stop him from doing that. You just can't start a new company and take WFG people. You can start a new company. You have plenty of options for employment. You just can't continue employment with the same people that you have. It claims that Mr. Olson perpetrated a violation of this restriction entitled WFG to divest Mr. Olson of his hierarchy, his team, his agents, and any outstanding commissions at its sole discretion. So he's claiming that WFG is doing all of this to him purely to separate him of his hierarchy, his team of agents, and any outstanding commissions. So WFG is greedy, and they're trying to take away his stuff. they're not doing it because he's breaking the contract. They're doing it purely because this is basically what he's saying, that they're doing it solely so that they can make more money off of him leaving. In divesting Mr. Olson, WFG has taken business Mr. Olson has required through his own efforts and through the purchase of Mr. Day's code for millions without compensation. WFG has further refused to pay Mr. Olson a bonus of $20,000 that was due in January, and claims that Mr. Olson further forfeited any right to receive earned commissions post-termination. Each day that WFG is able to threaten, so they're the aggressors, Mr. Olson and people who may wish to leave WFG's toxic environment and work with him, is suffering immediate and ongoing irreparable harm. Okay, so WFG's environment is so toxic, terrible atmosphere, that they're suffering, and they're ongoing irreparable harm, so that's why they need to go. Okay, causes of action. Mr. Olson hereby incorporate, okay, so this is going to be talking about, it's kind of a reiteration. So, though the conduct alleged above, defendant committed unlawful, deceptive, and unfair business practices. They're saying the defendant, so this is referring to WFG. So WFG committed unlawful, deceptive, and unfair business practices is Mr. Olson's claim. Mr. Olson lost money or property as a result of the defendant's conduct. WFG attempted to prevent Mr. Olson and others from leaving WFG to intimidate Mr. Olson and his agents violates this section of California Business Code. WFG is restraining Mr. Olson from engaging in his lawful profession under that particular lawsuit that's above, so you can go read that if you want to look up what that is. I have no idea what that is. As a direct and proximate result, defendants' violations of this code has been unjustly, so they're saying that WFG has been unjustly enriched as Mr. Olson's expense. In any amount not yet certain exceeds $12 million, WFG's action have caused and will cause irreparable harm to Mr. Olson, including the loss of his ability to engage in his business, loss of business contacts and agents, and loss of business opportunity. It's kind of what happens when you leave. You're still able to engage in business, just not with former WFG agents. Mr. Olson is entitled to injunctive relief, WFG's conduct, as well as other equitable and monetary reliefs. Okay, so now they're going to go through and basically say what he's hoping to get out of it. That he engaged in the business of recruiting agents, selling insurance products through Pinnacle. His relationship with Pinnacle in the past was likely to continue. Greater significant compensation. Defendants knowingly attempted to prevent Mr. Olson and others from leaving WFG to intimidate Olson and his agents through its use of its non-solicitation clause in violation of this California Business Code. Defendant's action interferes with Mr. Olson's business. Defendant's action, WFG's actions, caused economic harm in the amount to be proven at a trial. Upon his termination, WFG purported to divest and retain Mr. Olson's business and the other earned compensation. So this is kind of what he's saying is he's being hurt by the compensation commission earned by Mr. Olson and his agents hierarchy prior to its termination. So he wants that back. He wants all compensation on commission earned post termination. It's interesting. And a $200,000 bonus that Mr. Olson withheld. And those are the three things basically that he's asking for. So to kind of reiterate this, it's kind of like have you ever had to deliver a bad message? So you kind of put the good stuff on the top and the bottom. So all compensation on commission earned by Mr. Olson and his agents in hierarchy prior to his termination. So that's fair. Anything up until he got terminated, he should be paid. Absolutely. No questions asked. If WFG withholds that, that makes no sense. He also should get that $200,000 bonus that he was promised to be paid out in January because all this happened in January. Absolutely. Now, the question is, should he still get paid post-termination for everything that he's built? So if you get terminated, generally you don't get to keep your income. So I doubt that that's probably going to happen. Okay, Mr. Olson had previously purchased the right to compensation under Mr. Day's code for several $1 million. That's a good point too. What happens with that? If you buy somebody's code number, technically you kind of get to override that and you get the income off of that. So do you get to keep that after you go or after you're terminated? That is definitely one that's going to be open for debate as well. Mr. Olson is entitled to the return of his property, injunctive and monetary relief to be proven at trial. So he wants this at a jury trial, which makes sense because it's easier to play the victim, right? Because you just have to convince a couple people, hey, these big bad guys are after me. Whereas if we're actually doing it in a court of law, it's going to be a little bit different because you got to do it more by evidence than you do by convincing people. And Eric is fantastic at convincing. He's a fantastic leader. And basically, so what they're talking about has happened is that a breach of contract and covenant of good faith and fair dealing. This is what he's saying WFG is doing. Mr. Olson hereby incorporates by reference each and alleged allegation contained in this complaint. Mr. Olson entered into a valid and enforceable contract with defendant WFG. Mr. Olson performed his obligations under this agreement in all meritable aspects, except for the ones that he broke, I guess. Through the conduct alleged above, defendants breached the contract and implied covenant of good faith and fair dealing. So he's saying WFG broke that covenant. Mr. Olson has been injured and continues to be injured by WFG's breach of the contract of good faith and fair dealing and is entitled to compensation and relief to be proven at trial. Okay. So here's a little bit of a timeline. The actual controversy has arisen between Mr. Olson and the defendants in that WFG's termination, and as we talked about earlier in that paragraph 2.15 of not being able to solicit other WFG, you cannot solicit, entice, or induce, entice any way or in any other manner persuade or attempt to persuade any individual who is a current WFG agent. So again, go start your own thing, have fun, do whatever you want to do. You just can't take WFG agents with you, especially if you're going to do it through making stuff up. Agent has benefit of contract on behalf of WFG or its affiliated related entities to terminate or alter their agent relationship with WFG and join a competing organization. Mr. Olson contends the non-solicitation provision is unforeseeable as contrary to the law. So his main argument, his case is mostly going to base on, does the non-solicitation, does WFG saying, please don't come after our people. If you go, go, just leave our people alone. I shouldn't say our people, it doesn't sound right, but he's saying the non-solicitation violates this code. I have no idea what this code is for California law. So that's where the crux of this lawsuit is going to go. So if he can prove that this non-solicitation is somehow against the law in California, then he has something to go off of, and he can recruit all the people that he wants from WFG. He can move all the clients he wants over from WFG. There's no issue with that. I think he's going to have a hard time with that. A judicial determination is necessary. Obviously, we're talking about that. He wants relief that he's listed below, damages in the amount to be determined at trial, attorney's fees, punitive damages, and all other allowed under law, and whatever else the court deems just, proper, and equitable. Signed, Matthew Borden. So this is his lawyer on January 26th. There's a bunch of other lawyers that are up here at the top. I don't know if you know any of these guys, but that are going to be handling this case as well. So we'll see more. Oh, and pro has vice basically just means that they can't operate in California. They have a law license, but they're just not able to operate in California. So the laws are a little bit different in each state. So anyway, that's basically the documentation of this lawsuit between Eric Olson and WFG. So what we'll do probably Monday, I have the other document of WFG suing Eric Olson back. So we'll go through and we'll talk a little bit about that. And you can see WFG's response to this. Now, there are two other things that I want to cover. I want to go over Paul Hart's resignation letter because I couldn't get that to work last time. So let me bring that up and you can kind of see that because there's a lot of debate going on. I talked to Paul about this and he's saying he was terminated, but that's... This is basically his resignation letter, and you can kind of read this at your will. It's going to be a lot of the same things, basically like, we're sorry to see you go, but don't forget you can't come and recruit people, you can't take clients and do all that other stuff that you might want to do. So it's just kind of reminding him of the contract that he had signed. But this shows as a resignation letter. And he keeps saying that he was terminated. So if you have a termination letter for Paul, if you want to send it to me, I'll gladly post it. I don't have a dog in this fight. I'm just tired of my friends fighting and arguing with each other. And so if we can get actual information out there so people can make an educated decision, that's my main goal with this whole thing, because I'm tired of asking. I don't want to have to answer the same question 50,000 times. I'd rather do a video and you can watch it and determine what it is that you feel about it on your own. So if that's true, because he did this whole video of, hey, WFG stole from me, right? Like, he didn't say WFG, but he's like, I've been stolen from, and that's fine if you were terminated for no cause. But the question is, was there cause and did you resign? Why is there a resignation letter if you had something stolen from you? So I don't know. Anyway, that's still kind of open for determination. You kind of figure that out. And so this is just some of the stuff that's floating around on social media. And what's interesting here is remember we were talking about a couple of those things. You cannot entice people from WFG to come over and work with you. You can't take people who are currently contracted with WFG and move them over. That's the whole thing we're talking about in that it's not necessarily a non-solicitation, but did they call it? Yeah, I think it's non-solicitation, where you can't take those people over. So here's what's interesting is, these are just posts that have popped up on my timeline. I wasn't really even looking for them, so there's got to be way more of them out there. There will be 4,000 new business partners as of tomorrow. We're the fastest growing company in the entire financial industry. So my question to you is, are they breaking that contract, enticing agents, or did they just go out and find 40,000 people, or sorry, I keep saying 40,000, 4,000 people to join their team in the last, I don't know, 3 weeks, I think is how long this has been going on. So that's kind of interesting to me. And then another thing that becomes kind of interesting is they're saying that in this they say first 30 days here, they've done 1,100 applications. Anybody who runs a team here, I would love to have 1,100 applications done in a couple days. So my question here becomes, are they going back and churning their previous clients? So if somebody has a policy with, say, Transamerica or Nationwide, are they going back to those guys and saying, oh, you know, I left that company, or that company's not good, they're terrible, whatever it is that they're saying, let's rewrite that policy over here? Because that's a big no-no in the industry, and that's going to cause a lot of lawsuits if that's happening, especially if you're doing it on a major scale. You can get away with a couple. I don't think they would find out, but if you're going to do that, I wouldn't say probably all 1,100 of them, but that's a massive amount of business to be moving over. And this is why a company does a non-compete like that. You can't do a non-compete, but non-solicitation, because they don't want you to come in and rob all of those previous clients. Number one, it's just not good business practice. But number two, it's bad for the client. If you have an insurance policy, unless you can prove that it's way better, it shouldn't be being churned over. That's literally against the law. But it's bad for the client because they're already in that contract. They're now older. Things have changed in most cases. So you're getting people to get rid of their old contracts and come over. I don't know. That just doesn't seem like transparency. That doesn't seem like doing the right thing and starting a new business. And this is just what I'm seeing from the outside, so it's my interpretation. I understand you got to have a lot of hype, and you got to fire this thing up to get people moving and to get them to move over. But are you doing it the right way if you're taking people and you're taking clients? I'll leave that up to you guys to kind of decide. And so that's what I had to go over today. I guess on Monday, that one's a little bit longer to be able to go through. We'll talk about what WFG is saying against Eric and kind of get their side of things, so that you can get the aspect of both of them and kind of make your own determination on what you feel about what's going on. The lawsuit, in my impression, just my personal opinion from here, is that it doesn't look good for Eric. I don't know how he's going to get it to say that, yeah, I broke the contract, but somehow it's okay because the contract's kind of against the law, and so I should be able to go in and rob people from a former company and clients and bring them over here. I don't know how that stands up in an actual court of law. That seems like a weak argument to me. And the worst he could say about WFG was that you're enticed to sell Transamerica products because you get a little bit higher compensation, which is also fascinating to me because isn't that 90% of what they're telling their guys to come over and get recruited is that you have a higher compensation? So like you're blaming WFG for something and then you're literally doing the same, like you're talking out of both sides of your mouth. You're supposed to be doing what's best for the client, but yet you're saying WFG isn't doing that. And the reason why you should leave WFG for not doing that is because you can come over here and make a higher commission. So like, you know what I'm saying? That just doesn't make sense to me as far as an argument goes when your actions are proving something different. So anyway, that's what I have. That's enough of my rant for today. I'll bring you guys more information as I get it. There's so much that's out there, so I'll try to break it down into bite-sized pieces so you can see literally what's going on, because I'm tired of the politics. I can't get straight answers from anybody on either side. Nobody wants to talk about it. If somebody wants to come on and have a conversation and we can do a little bit of an interview, like, let's do that too. I'm open to all of it. I want my friends to stop fighting. I want this, to just, however it resolves. If you want to go. That's perfectly fine. Like, but I don't think we need to be fighting about it. And the lack of leadership in having these conversations, I think, is hurting more than it's helping. And if somebody would just come out and have a conversation of what's actually going on, because people's livelihood are at stake. If you've got a decent sized business here and you're going to leave, you're going to not be able to take your stuff over. And if you're going to try to move people over, I would bet you WFG is going to come after you. So your livelihood is at stake. Maybe you can go recruit and rebuild somewhere else, and that 5% difference in the contract is going to make all the difference in your life. Maybe, but I don't know, man. I just don't want people to get sucked up into this and look back and regret it. And if you make an educated decision and you go, that's fine. But unfortunately, there's no real information out there. It's all just propaganda from both sides, or nothing from one of the sides. And so just make an educated decision is all I'm trying to say. Anyway, love you guys. I hope that was helpful. I hope that breaks it down. I hope this keeps me from having to answer a million questions. But I love you guys. Appreciate you. Whatever you decide to do, take care. Catch you guys later. Bye.